Welcome, and thank you for joining Seyfarth's webinar, Overview of Non-Compete Legislation and Enforcement Issues from 2021. All participants are in listen-only mode. You are encouraged to submit questions throughout the program using the Q&A box on your screen. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and presentation materials will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to Dawn Mertenite.
Thank you, Colleen, and welcome to everyone. Thank you for being here today. We have a packed agenda today. So here you'll see, I'm going to talk a little bit about just an overview of restrictive covenants, and then we will get into a discussion of new and pending state legislation. Eric will talk about proposed federal legislation, and finally, Josh will be talking about some common enforcement issues that our team and our clients are dealing with frequently these days. So here are your panelists, myself, Eric, and Josh. As you can see, we are in different offices. I'm in Boston, Eric is in Atlanta, Josh is in LA, and we have team members all over the country. So we can help you basically wherever you need it. So let's move on and we'll start talking a little bit of a high-level overview of the landscape of restrictive covenants law. So this year alone, there was close to 70 state bills pending on non-competes. Now, candidly, between the time we set up this presentation and today, there may have been more. Needless to say, this is a hot topic, a lot of activity in state legislatures and also on the federal level. As you'll see here, there have been significant changes and there are proposed changes both in states and at the federal level. And we have been seeing an increased scrutiny from the federal government that we had not previously seen, even in an area that normally is left up to the states. So as I mentioned earlier, Eric will let you know a little bit more about that once we get into the slides later. And then there are greater challenges these days for employers that have workforces in multiple states. And again, I won't delve into it too deep now. Josh is going to talk to you about this at the end of the webinar. But one of the things we see frequently are issues with choice of law and venue challenges. There are more and more states now that are making requirements for their residents. There are new fee-shifting statutes, and I'll be talking about a couple of them. That's also becoming pretty common. So employers need to be really careful about how they craft their agreements because they could end up not just with an unenforceable agreement, but they could be forced to pay a former employee if they try to enforce a non-compliant agreement. And just generally, it's not easy anymore to roll out an agreement that covers all 50 states. We can certainly do it. We have done it. We do it for clients all the time, but it's no longer the case that there is one agreement that will work for every single employer, regardless of where they are. So it is a challenging area of the law, and it's really important to stay abreast of all the new changes and the quirks in each state. So let's move on to what has actually been happening in states and the new laws and new pending legislation. We are going to start with Illinois. So Illinois has a new law that will become effective January 1st of next year. And like a number of other states, the new law provides earning thresholds for certain restrictive covenants. So you can see here we have a chart. Starting in 2022, employees who make less than $75,000 a year cannot be bound by non-competes. And that number jumps up every 5 years, as you can see here, $80,000 in 2027, $85,000 in 2032, and finally, $90,000 in 2037. Many states have either just a ban on so-called low-wage non-competes, or they have the same wage thresholds for all restrictive covenants. Illinois is unique in that it's really the first state that has created two different levels. And so as you can see here, there are also earnings thresholds for non-solicits too, and those are a little bit lower than non-competes. So 2022, if you have employees who make less than $45,000, they can't be bound by either a non-compete or a non-solicit. And again, that number also bumps up every 5 years, as you can see here. As you can see on the next bullet, earnings in the statute are defined as all salary, earned bonuses, and commissions, and any amounts electively deferred by the employee, such as contributions to a 401k plan. Another interesting aspect of the Illinois law is codification of the so-called Fifield rule. If you are not familiar with Fifield, it was an interesting case in Illinois from several years ago. You may be familiar with the concept of continued employment as sufficient consideration. And basically what that means is in about half the states, give or take, if you give an agreement to an existing employee, continued employment with the company is sufficient to support that agreement. And in the other half, give or take, of the states, it's not sufficient. And if you're going to give an agreement to somebody who's already started working, you need to provide either a bonus, a raise, a promotion, or something else. Fifield was kind of interesting because the court in Illinois said continued employment is sufficient consideration provided the employee stays on for 2 years or more. And what's really odd about Fifield is that's the case even if the employee voluntarily resigns. So you could roll out a new agreement to an employee that's already existing and say, as consideration for this agreement, we're going to keep you employed. And if that employee decides a year later to leave, the non-compete and other restrictive covenants are probably going to be unenforceable. So what the statute does is it codifies that rule. And so basically you need to either be sure that the employee is going to stick around for 2 years after they sign the agreement, or you need to give them other considerations such as additional professional or financial benefits. So again, that's typically a raise, promotion, access to additional confidential information, or something like that. So let's go to the next slide. Also a new function of the new statute. There is now a notice provision, The employer has to provide a copy of the non-compete at least 14 calendar days before employment commences. We see this in some other states. Unlike some of those other states, at least in Illinois, that is waivable by the employee. So you could give the non-compete to somebody that you want to bring on. They could sign it sooner than 14 days and get started right away. So that's fine, but you need to give them 14 calendar days if they want it. Employees also have to be notified of their right to consult with counsel for the non-compete to be enforceable. So next slide, please. Fee shifting. I will talk about this again, and I think Josh is going to talk about it as well. If an employer uses an agreement that violates this new statute, the employee could be entitled to recover their costs and reasonable attorney's fees. So again, this is something that's becoming much more common. Employers really need to be careful to make sure that their agreements are reasonable and comply with the relevant laws, because it's no longer the case that if you have an overbroad agreement or it otherwise violates part of the law, you just have an unenforceable agreement. No, now you could be on the hook for paying the former employee if you have an agreement that violates the statute. Finally, reformation. You may understand already that there are some states that allow for judicial reformation. So let's say the non-compete says that you can't compete within 200 miles, and a judge says that seems a little too far. I think 100 miles or 50 miles is a little bit more reasonable. Some states will allow the court to make that reformation. In Illinois, the new statute discourages extensive reformation, and there are certain factors that the statute guides the court with and wants the court to consider in determining whether to reform an overbroad agreement. So you'll see here the fairness of the restraints as originally drafted, and whether the original draft shows a good faith effort to protect a legitimate business interest. We used to see, and we still sometimes see, agreements that are very, very broad, and it's clear that the employer thought, well, let's go as far as we can, and we know that the judge will limit it if need be. That's really not a good way to do business anymore, because you could end up in Illinois and other states, you could end up with a situation where the judge says, I see what you were trying to do. You were trying to get an overbroad agreement enforced. I don't want to enforce that. I'm not even going to reform it because I don't think you made a good faith effort to try to be reasonable. So that is something you need to be careful about. So next, we are going to look at Nevada. So Nevada's statute has already gone into effect. The effective date was October 1st of this year. And as I just mentioned, low-wage employees, this is a new thing that we are seeing more and more. There are a number of states, Virginia, Massachusetts, you can see it, several here listed. Of course, it would be too easy if every state had the same definition of what a low-wage employee is, but in Nevada, it means employees who are paid solely on an hourly basis, exclusive of tips or gratuities. Another feature of the Nevada law is that employers cannot enforce customer non-solicits that would prohibit the former employee from even accepting business. So it is still fine to have a provision that prohibits a former employee from going out and soliciting their customers, assuming it's otherwise reasonable. But if the agreement says, if your former customer comes to you without you reaching out to them and they say, I want to do business with you, you can't accept it. Those sorts of provisions are no longer enforceable. If a customer reaches out to a former employee of their own accord, that's, that employee can take that business. Finally, again, here's another fee shifting statute. So the employer would be liable for the former employee's attorney's fees and costs if the restrictive covenant violates the statute. And notably, this applies even if it's a declaratory judgment suit. So we see this from time to time. An employee leaves and they filed the lawsuit first saying, I think my covenants are overbroad, unenforceable. And if they win, they will be entitled to their fees. So something to be mindful of. Next, we are going to move to Oregon. Oregon has an update for the fourth time in 6 years. Apparently, the legislators there just love to talk about non-competes. So this statute was effective May 21st of this year, and a few changes from the previous statute. The maximum duration of a non-compete has decreased from 18 months to 12 months. And again, you might be noticing a pattern here. There's a new compensation threshold. Non-competes will not be enforceable unless the employee has gross annual salary and commissions at their termination that are in excess of $100,533. And like their neighbors to the north, that threshold will be adjusted annually for inflation. So you're going to have to keep an eye on what the new threshold is every year. Non-compliant agreements are void, not just voidable. So what does that mean? Oregon had a bit of a quirk where the previous statute said that if an agreement was in violation of the statute, it was voidable by the employee. So that meant an employee, before they left, could say, I don't think my agreement should be enforced because it violates, this aspect of the statute or that aspect of the statute. But if they did not do that, if they did not proactively void the agreement and they left, those statutory infirmities would not matter, essentially. The legislature obviously realized that, that's an odd quirk. And as far as I know, no other state had that. And so now they say, look, even if the employee doesn't realize it, if the agreement somehow violates the statute, it is void. The employee doesn't have to do anything for that to be the case. All right, so finally on my list of states, although not a state yet, Washington, D.C. So this is a big one. This would prohibit the imposition of non-competes for employees working in D.C. So it would join just a handful of other jurisdictions in the country that do that. There are some exceptions that I've listed here. You'll see it doesn't apply to D.C. or federal government employees. It's also not applicable to volunteers of certain types of organizations, lay members that are elected or appointed into office in religious organizations, casual babysitters, which I have to imagine was a result of congressional lobbying, and then certain types of physicians. Even more striking, I guess is the word, is the fact that this statute would prohibit even anti-moonlighting provisions, which is stricter than California, which we all consider the strictest in the nation. So basically what this means is if this version of the statute goes into effect, an employer could not tell its existing employee, while you are employed by us, you cannot simultaneously work for our competitor. So that's a big deal. No other state or jurisdiction in the US has that sort of rule. So let's move on to the next slide. The statute also has anti-retaliation provisions and a notice requirement. You can see here, this is the language that employers with workers in DC need to use. No employer operating in the District of Columbia may request or require any employee working in the District of Columbia to agree to a non-compete policy or agreement in accordance with the Ban on Non-Compete Agreements Amendment Act of 2020. And this notice needs to be provided at a variety of times. So within 90 days of this statute becoming effective, which we'll talk about in a minute, within 7 days of a new hire, it needs to be given. And if an employee requests notice, you need to give it within 14 days of their request. So next slide, please. Liability. This statute provides a private right of action for any violations. And in that event, employees can recover anywhere between $500 and $2,500 for each violation, and then at least $3,000 for subsequent violations. And even if an employee does not bring their own action, the local authorities can fine employers who are in violation of the statute by at least $350 up to $1,000, and for retaliation, no less than $1,000. So the big question here is, when is this going to go into effect? Because it's a big deal. We don't know. This law initially was enacted in about March of this year, and it was going to be effective as soon as DC passed a budget, which happened in the fall. So everyone was gearing up for that. But somewhere along the way, because it got so much pushback, the legislators there realized we need to reconsider this. So there are some amendments in the works. Implementation has been put on hold. I suspect that the anti-moonlighting ban is going to come out because that got a lot of pushback, but it remains to be seen. So stay tuned for that. We will update you on our blog. And finally, before I turn it over to Eric, what can we expect in 2022? So at the top of the hour, I told you that there were almost 70 bills pending. Some of those have died. And obviously we talked about a few of them that passed, but there are still about 26 non-compete bills that are pending in 9 states. I'm not going to go through all of them because who knows if they will pass or not, but you can see on this slide a smattering of what is left. In New York, there are a couple of different bills in the works. One of them would ban non-competes entirely, so stay tuned for news on that. Wyoming, same thing. There's a full ban on non-competes that the legislature is considering. There are 4 bills pending in New Jersey, and this one is really onerous for employers. Who knows if it will pass, but it would require an employer to pay the former employee's salary, the full salary, and pay for their benefits for the full restricted term. So that obviously can get very pricey. That will be big news if it passes. I doubt it will, but who knows? And then you'll see here there are a number of other states that are considering things, including states that just passed bills relatively recently. We talked about Illinois today. Massachusetts had a statute passed in 2018, so it's only been 3 years and they're already considering amendments to it. So as I said, there's a lot of activity in this area of the law, so stay tuned. And with that, I will pass it along to Eric, who's going to talk about federal legislation.
Thank you, Dawn. And it's my pleasure to talk to you all today about proposed federal legislation in the restrictive covenant space. As we've certainly seen an uptick in recent years by the federal government to enact non-compete legislation that would supersede the various state laws and create a more uniform approach to non-compete agreements. And 2021 absolutely continued that trend, and in fact probably increased it due to the change in the new administration. So far, those attempts have not been successful. So everything we're going to talk about, there is no new, spoiler alert, there's no new federal law that has passed or we'll see that is even probably on the brink of passing. But as they say, if at first you don't succeed, try again, and that is exactly what is happening this year. The first proposed legislation we'll discuss is the Workforce Mobility Act. Next slide. This is a proposed act that was introduced back in February of 2021. As you can see, it's still in committee, so it hasn't even gotten out of the sort of most preliminary stage. It is a bipartisan bill, albeit limited, primarily Democrats, but there are a couple Republicans who have signed on to the Workforce Mobility Act. Next slide. This act actually, and we won't get into all the weeds, but it actually is somewhat of a continuation from a proposed act by the same name in 2019, which did not become law, obviously, but it's a continued push, a redoubling down on trying to get some traction on this. As everyone is aware, and as Dawn was just explaining, every state currently is pretty much free to enact its own laws. Those laws vary quite extensively, from the folks out in California to the law we have here in Georgia, for example, and everything in between. This new bill would take the power really completely out of the state's hands and impose one uniform policy that would impact the entire country. And the primary goal here really is uniformity. Next slide. It would, and I've put some bullet points up on the screen. You can see, if passed, this bill would drastically limit the situations in which an employer could require an employee to sign a non-compete. And in fact, non-competes, as I note, could only be used in situations involving the dissolution of a partnership or the sale of a business. And that's it. Obviously, that is extremely different than what we have now in the vast majority of states. It would also place the enforcement responsibility on the FTC and the Department of Labor, as well as continuing a private right of action. And this idea of empowering federal agencies, and the ones we typically see are the Federal Trade Commission and the Department of Labor, has really become a reoccurring theme in a lot of proposed legislation. And even on state levels, as Dawn alluded to in DC, for example, where they wanted their local agencies to be able to enforce things. So it's not only is it the government, federal government in this case, really trying to ban non-competes, but in addition to just a private right of action, having federal agencies act as, for lack of a better word, sort of the police on it, and be able to bring actions against violating employers. As you can see, it would also require employers to make their employees aware of the limitation on non-competes. Again, a lot of devil's in the details there. We've seen a lot of states do versions of this already about particular language that they must include, or periods of time, as Dawn alluded to, the 2-week period, I think that was Illinois, where a person has to be given the right to consider it. The idea being you can't hide a non-compete into an agreement. And finally, the Department of Labor would also be given authority to make the public aware of the limitation. Again, at this point, it's unclear about exactly what that means. Maybe it's a new poster that we're required to hang in break rooms, to be determined. Next slide. And suffice it to say, if passed, the impact of this bill would be extensive on every aspect of non-compete law in the United States, and it really would be a sea change for what we have now. Employers would no longer be able to limit their employees' ability to go to work for a competitor, obviously, unless it was in the limited exception of a dissolution of a business or a partnership or a sale of a business. And that would lead to competitors being able to freely poach one another's employees and really no legal remedy to stop it. And again, before everyone gets too excited or too worried, depending on your personal perspective. Again, I'll reiterate that all prior attempts to impact federal non-compete legislation, including ones, and there have been ones in the past that have been bipartisan, this is not the first, have all failed. And at this point, the best intel that we have suggests that the enactment of the proposed Workforce Mobility Act is probably still quite a bit of a long shot. And even if it makes itself out of committee, we suspect that it would be subject to heavy lobbying from both sides on a whole host of issues. That takes us to our next proposed federal legislation. This one is called the Freedom to Compete Act. And whereas the Workforce Mobility Act really wanted to completely rewrite or redo the non-compete law in the United States, the Freedom to Compete Act takes a much more narrow or targeted approach, and as we'll see, is attempting to enact on a federal level things that a lot of states are doing already. So this is a proposed act that was introduced back in July. It, like the Workforce Mobility Act, is still in committee, so it isn't even out of the preliminary phase yet. Its primary sponsor is Marco Rubio. Joined with him is a Democratic senator from New Hampshire. And as you can see here, the stated purpose of this act is to protect, quote, entry-level low-wage workers from non-compete agreements that limit their employment opportunities. And that is really the key here. It is focused on essentially making sure that entry-level or quote-unquote low-wage workers are not burdened or subject to non-compete agreements. And it would amend the Fair Labor Standards Act to prevent employers from using non-compete agreements in employment contracts for certain non-exempt employees. As you can see, this is not the first time that Senator Rubio introduced this type of legislation. He did back in January of 2019. It obviously did not pass then, but he's attempting to get more bipartisan support this go round, and that is where it currently is at. I want to make a few additional notes about it if we go to the next slide. So specifically, what would this bill do if enacted? And again, we don't have a great deal of information at this point, but from what we do know, it would only again apply to employees who do not qualify for the FLSA minimum wage and overtime exemption. As you can see, there are some carve-outs here, such as for outside sales employees. But again, the real focus is protecting and preventing low-income earners from being saddled with non-compete agreements. And as you saw, there really is a trend across the United States. Dawn highlighted a whole host of states: Illinois, Nevada, Virginia, Washington, others, and others are in the pipeline that are doing specifically that. States that don't want to go as far, if you will, as California and say, well, they're not valid here. I'd probably as a attempt to keep the businesses happy, businesses who want them, but at the same time recognizing that there should be a limit on them, and they're viewing a reasonable limit is tied to income. Second bullet point references that it will prohibit an employer from enforcing or threatening to enforce a non-compete with a non-exempt employee. So again, the law seems to be targeted at, and we see this in states as well, where they don't want you even threatening to enforce an agreement. It would prohibit an employer from entering into, extending, or renewing a non-compete agreement with a non-exempt employee. And here, once again, it's our continuing theme. They're suggesting that it be enforced by the Department of Labor under the existing FLSA framework for minimum wage and overtime violations. So again, more than just a private right of action, but trying to back it up with a federal agency that would be able to enforce violations or potential violations. So we're continuing to keep an eye on both of those pieces of federal legislation as we head now into 2022. If we go to the next slide, The next topic we wanted to talk about was, or touch on, was Biden's executive order. This was an executive order that came out back in July of 2021. And if you want a more detailed discussion on this, I would refer you to the Seyfarth Trading Secrets blog. There's a blog entry on this with a lot more detail, but I wanted to hit a few of the high points. So back in July, the Biden administration released an executive order. It was entitled Promoting Competition in the American Economy. And the executive order really was just a general call to rulemaking versus a definitive or authoritative directive on the Federal Trade Commission. If we go to the next slide, the executive order, its words were, it encouraged the Federal Trade Commission to, quote, consider exercising its statutory rulemaking authority to curtail the unfair use of non-compete clauses and other clauses or agreements that may unfairly limit worker mobility. The directive, as I know, doesn't have an immediate legal impact. Rather, it just encourages, as the executive order states, the focus on unfair agreements. We go to the next slide. Interestingly, the language of this executive order, for those who particularly followed the Biden administration's campaign, it's much softer than what he was pledging that he would do if elected. During the campaign, he pretty clearly stated that he would work with Congress to ban non-compete agreements altogether. And to be clear, this executive order does not do that. Again, it does not even encourage a wholesale ban. It instead directs that rulemaking should, quote unquote, curtail the unfair use of non-competes. And obviously, what is meant by unfair use, or even what is meant by curtailing, is not entirely clear. Though we do have some hints about potentially what the Biden administration meant with this particular executive order, if we go to the next slide. We believe that, and we'll talk about in a second, that non-poaching agreements will likely continue to get additional federal scrutiny. The executive order encouraged the Attorney General and the FTC to consider revising the antitrust guidance for the human resource professionals issued back in October of 2016. And that is exactly what has happened. Over the last 6 to 12 months, the Antitrust Division at the Department of Justice has obtained a multiple count indictment against a healthcare company and related entity for agreeing not to solicit senior level employees. And based on our analysis, we believe this indictment is the first criminal antitrust indictment for a no poaching agreement between employers. We'll continue to watch this space as we head into 2022, particularly as it relates to the non-poaching and actually seeing federal agencies get involved in areas that we, as private litigators, has generally been left to private litigation between parties. But particularly with the Biden administration, and particularly with this executive order, we think there's going to be a lot more activity on the federal front from agencies attempting to enforce a whole host of restrictive covenants. If we go to the next slide, I'm gonna close by just touching very, very briefly on a recent virtual public workshop that happened. It was the DOJ and the Federal Trade Commission virtual public workshop. It took place just earlier this month, a 2-day workshop, December 6th to 7th. And it was to discuss efforts to promote competitive labor markets and worker mobility. And again, we think you can pretty much connect the dots pretty clearly between Biden's executive order and these type of public workshops taking place with government agencies, where they are bringing together lawyers, economists, academics, et cetera, to cover recent developments in antitrust and labor, and discuss the implications for efforts to protect and empower workers through competition, enforcement, and rulemaking. In other words, from a federal level down, what are ideas that and what are concepts for laws that should be enacted to, from this administration standpoint, encourage competition and workforce mobility. The panelists were invited to discuss potential steps for antitrust enforcers. We are going to look for, I referenced the Seyfarth blog earlier, pay attention to that space. We will get a blog post out on this particular workshop, but it was intended to essentially be a type of think tank or venue for sharing new arguments and ideas and proposals in the sort of federal restrictive covenant space. If you flip to the next slide. And just briefly, some of the topics included the following: the increased use of restrictive contractual clauses in labor agreements, information sharing and benchmarking activity among competing employers, and the role of other federal agencies in ensuring fair competition in labor markets. Again, probably one of the hottest topics in 2021 and certainly likely into 2022, that the role of federal agencies in ensuring fair competition in labor markets. So again, more on that as we digest that workshop. But with that, I'm going to turn the presentation over to Josh.
Thanks, Eric. Before we turn to the last section, I wanted to give out the CLE code. And so it's going to be a 6-digit code, and that is SS as in Seyfarth Shaw 2532. That's SS as in Seyfarth Shaw 2532. Next slide. And so as we go into the Slack section on enforcement issues, I have this a quote up here that I think is particularly noteworthy in that, in light of all the changes and amendments we're seeing with non-compete laws, there's an additional issue that employers are facing regards to this, the idea of a great resignation. And so in this quote from the Wall Street Journal this past summer, it said that forget going back to the office, people are just quitting instead. And we've seen that one of the top issues facing employers as they're coming out of the pandemic, but then also facing potential new either lockdowns or restrictions, that this issue of a great resignation is something that's really taken priority. And we are just simply seeing employees leave the workforce at an unprecedented rate. Next slide. And so we wanted to cover this because for two kind of general reasons. One, there's obvious concern that employers have with their workforce retention and then recruitment for new employees. But there's also important potential legal risks when either enforcing restrictive covenant agreements against departing employees, evaluating candidates or recruits who may have covenants with their prior employers and how that may affect their ongoing or their future duties and responsibilities for the new employer, and then just considering whether to implement any new or revised covenants going forward to protect the business. The second thing I think which companies can't lose sight of is while there is an understanding that non-competes can be used in certain states and certain circumstances to restrict competitive activities post-termination, the restrictive covenants can be used for other legitimate business purposes, whether that's to protect trade secrets or confidential information, to protect client or customer relationships, to protect goodwill, and otherwise to just protect valuable business assets. And so you can see the statistics here. They are eye-opening, but may no longer be surprising now. We've seen on average about 4 million employees leaving their employers each month, with about 4 million, about 3.9 left in June, 4 million in July, And we saw this trend continued. I think in August, it was also another 4.3 million. And so we're seeing the employees resign at an unprecedented workplace, at an unprecedented rate. I think what is even more consequential is that the polls are showing that about half of employees are actively searching for new jobs. And it's even more if you look at Gen Z employees in particular, and those would be employees who are under 25 years of age. And in digging into this data, the Harvard Business Review found that mid-career employees in particular, generally folks who are between the ages of 30 and 45, were the ones who were having the highest resignation rates. And when asked the employees why they were leaving, this group in particular expressed a greater level of discontent with their current jobs and a stronger desire for more flexibility. Some of the issues they talked about most were involving pay and compensation, the workplace environment, and then that flexibility, which we've seen has been more tied to the places where the employee can work and also when they can work. And this is particularly important for restrictive covenants that we're going to be discussing today, because there's these additional potential issues when you have this remote workforce or changing workforce that may be now working in different states or even different countries than they did before and after they've signed any prior employment or restrictive covenant agreements. Some of the data on the employee resignation have also shown that these employees are reaching a breaking point, that there's this pressure that has led them to leave and to look for a better workplace environment where they may feel more either valued or appreciated. And then some of this attrition is also to the fact of this competition for talent. You have this increased demand for competent, engaged employees, but a reducing supply. And we are seeing that additional compensation, both signing bonuses are increasing, just showing that some of this attrition is due to the competition for talent. And so the reason we are talking about this is because attracting and retaining employees is one of the top issues facing most employers right now. The bottom line is that these organizations need to have qualified and engaged employees to do their best work. And kind of going back to the restrictive covenant issues, these restrictive covenants can play a significant role in protecting the company's business and valuable business assets, but care has to be taken understanding a number of different enforcement issues. Next slide. So as we're seeing companies utilize more of a remote workforce, employees who are in different locations, and having different, more flexible workplace arrangements, one of the significant issues we're seeing with enforcement is concerning forum selection and choice of law. And these are essentially for forum selection, you can have a contractual provision in an employment or restrictive covenant that just designates where any disputes arising from or related to that agreement or relationship are going to be taking place, whether it's in a specific state or another specific venue. With choice of law, you have a contractual requirement that the governing law for the interpretation of that agreement or any related disputes is going to be governed by that designated law. And so these are not uncommon to see in employment or restrictive covenant agreements. There are significant advantages that employers use. For example, you have more uniformity, predictability if you have employees in different locations, different states, and want to designate one sole venue or state for forum. And there's the additional benefit of reducing any potential unnecessary costs and expenses when having to litigate disputes in a more distant forum. With forum selection, we saw a boost to enforcement with the Supreme Court's Atlantic Marine decision a few years back, which held that forum selection clauses are enforceable except in these exceptional circumstances. And we've seen, particularly the district courts, were routinely upholding these forum selection clauses acknowledging that either on motions to dismiss or transfer or something challenging venue, that the key focus was to really look at whether the underlying contractual form selection clause was enforceable, and not looking to leapfrog that to look at the actual, the impact of what state's law may apply if the dispute was transferred to a foreign forum. With choice of law, it's generally a state-specific analysis depending on what section of the restatements the law may apply regarding the conflicts of laws analysis. But we're seeing with these contractual choice of law issues that the contract's choice of law provision is considered valid unless there's no substantial relationship to the parties, or if the transaction or application of the chosen law is contrary to the fundamental policy of a state with material greater interest. And again, different states may have a different analysis depending on what part of the restatement they follow. But we're seeing with these form selection and choice of law analysis that more and more states are implementing some additional restrictions that are trying to prevent either employers or other parties from either circumventing that state's laws, or trying to get the dispute to be litigated in a different forum or to get a more favorable law applied. We saw with California, they enacted Labor Code 925, which prohibits employers from using, as a condition of employment, agreements for employees that primarily reside or work in California from entering into these agreements that require them to litigate in a different forum or under another state's laws. And then there's some additional exceptions and conditions for that statute as well. Washington, we've also seen requirements that non-competes must be governed by Washington law if the employee is Washington-based, and such individuals cannot be forced to litigate the non-compete outside of Washington state. And so understanding the form selection and choice of law risks is important, and counsel should carefully investigate and analyze the local laws of each forum and potential convenience of the distant forums before designating a particular forum and choice of law. And so we anticipate that this is going to be a significant issue that's going to be litigated kind of going forward, especially with situations where the employees are moving to different states and different locations. Next slide. Now, regarding some more California-specific issues, as we highlighted before, California has received some notoriety for being one of the more employee-favorable states for allowing the employees to pursue their chosen profession or career. With California Labor Code, or with California Business and Professions Code 16600, it prohibits agreements that restrain an employee's or a person's ability to pursue their profession. And there are certain circumstances that allow for exceptions, for example, the sale of a business or dissolution of a partnership. But generally, California is seen as the one of the few states that has a stronger public policy against employee non-competes. But we have seen within the last year or two some non-compete related decisions that are strengthening the ability for businesses to enforce non-competes outside of the employment relationship, for example, in business-to-business agreements. There was a Ninth Circuit decision, a recent Ninth Circuit ruling in a dispute between two healthcare staffing agencies that clarified that non-solicitation provisions in business-to-business collaboration agreements were not per se violations of the Sherman Act. This case was notable because it highlighted the tensions at the intersection of employment non-solicitation agreements and antitrust law. This case was also significant because it stands for this proposition that solicitation agreements that are ancillary to these larger collaboration agreements can serve a legitimate pro-competition purpose and does not necessarily violate federal antitrust law. Continuing on that trend with using non-competes outside of the employment setting. There was a significant decision last year in the Ishel case in which the California Supreme Court held that restraints in contracts between businesses should be evaluated using the same rule of reason standard that courts use to analyze antitrust violations. And so this was a boost to business non-compete agreements, and that the agreements were not automatically considered to be potential per se violations of 16600, but there was a new more reasonable rule of reason standards that could be used to enforce, to analyze the enforceability of these agreements. After the Ishel case, there were two notable decisions that came forward. One, there was a California Court of Appeal case that applied the rule of reason standard to uphold an exclusive dealing arrangement between two biotech companies. And then we also saw a U.S. Federal District Court issue a ruling that found that a provision preventing current distributors from inducing other current distributors to join external business opportunities did not invoke 16600. So these cases are going to be helpful for those business-to-business agreements, and that they're not going to be considered or treated in this more restrained fashion that the employment agreements are considered in. Next slide. In addition to the more, I guess, plain language non-compete agreement issues, there was a notable case that came out last year regarding the use of confidentiality provisions that may be seen as overly broad. There was a Court of Appeal decision that reversed a judgment confirming an arbitration award, which, examining the arbitrator's findings, ultimately invalidated a confidentiality provision in an employment agreement under Business and Professions Code 16600. In that case, the court had concluded that the employee who had this confidentiality provision as an employment agreement, the court found it was strikingly overbroad because it had this effect while not being an explicit non-compete. The breadth of the confidentiality provisions had the effect that it essentially prevented the employee from working in his industry for the rest of his life. And so it's important when evaluating whether it's restrictive covenant agreements or non-disclosure agreements for California employees, or agreements that are going to be bound by California law, that even if there's not an express non-compete provision in the agreement, that the non-disclosure provision should be reviewed closely to make sure that it doesn't have this overly broad scope and have the effect of a de facto non-compete. And then last, regarding the California specific issues, one kind of hot topic that is going to be likely continued to be litigated is the validity of non-solicitation of employee covenants under California law going forward. There was a significant decision in the 80s under California law, the Loral decision, which found that which enforced the use of non-solicitation of employee covenants that were reasonable. About a few years ago, there was a decision, the AMN healthcare decision, which questioned the validity and viability going forward of Loral, and found that for an employer that used non-solicitation of employee covenants in the healthcare staffing industry, the court found that that was invalid. And so recently, there's been some federal court decisions which have followed that more recent AMN healthcare decision to invalidate employee non-solicitation covenants. But then there's been some other trial court and out-of-state decisions who have recognized the ongoing validity of the prior Loral decision. And so right now, there's an apparent split in legal authorities regarding whether non-solicitation of employee covenants remain valid going forward. And so when looking at that, if company is going to be considered using non-solicitation of employees provisions, they should be aware that there may be additional potential risks, legal risks, if such covenants are later found unenforceable or invalid. And those potential risks could include something, for example, like a claim under California Business and Professions Code 17200, which may lead to potential exposure for injunctive relief or the employee's attorney's fees. And next slide. And so the last topic, which we briefly discussed earlier, was fee shifting. We've seen more and more states incorporate fee shifting provisions to give more teeth and to give more strength to the abilities, to the employee's abilities to either invalidate or challenge their restrictive covenant agreements. With California, we saw Labor Code 925, which provides that in addition to injunctive relief and any other remedies available, a court may award an employee who is enforcing his or her rights under this section their reasonable attorney's fees. As Don briefly went over earlier, Illinois, with their new statute, provides that in addition to any other remedies available under contract, if an employee prevails on a claim to enforce a covenant not to compete or a covenant not to solicit, that the employee shall recover from the employer a cost and all reasonable attorney's fees regarding such claim to enforce a covenant not to compete or a covenant not to solicit, and the court or arbitrator may award appropriate relief. And then also, as we discussed earlier with Nevada, AB 47, any person injured or damaged directly or indirectly in his or her business or property by reason of a violation of the provisions of this chapter may institute a civil action and shall recover treble damages together with reasonable attorney's fees and costs. And so, there's not only the risk of having either unenforceable or invalid agreements deemed no longer enforceable or void, but now the employee has the potential path to request and pursue their attorney's fees, which adds some additional business and legal concerns when implementing these types of restrictive covenants. Next slide. And so that concludes our presentation. We want to thank everybody for attending today. If you would like any additional information on these topics and track some of the new topics that are going to be closely monitored going forward, you can check out our Trade Secrets blog, which is at www.tradesecretslaw.com. We also have our newly updated 50-state desktop reference, which you can request to get a digital copy from us.
And I just wanted to add that I see that we received a ton of questions, which is great. I apologize, I did not see them while I was doing my section, and we now have, unfortunately, 2 minutes left. So we can't get to them now, but we will reach out to you and respond to your questions. We have a record of who asked us what, and we will be sure to reach out to you in the next couple of days and respond to your questions. But thank you, everyone, for attending.